Custody agreements can get tricky when you worry about your child's safety during visits with the other parent. A common question I hear from parents is whether they can legally deny visitation to the non-custodial parent. In the next few minutes, I'll talk about when denying visitation might be an option and the potential consequences. So if you already have a parenting time schedule arranged or filed with the court, it's very difficult to deny a parent parenting time. It's only in extreme circumstances where the court will grant that. The standard the courts look at is there an imminent danger of physical or emotional harm to the child? The court's going to require proof. And so you have to ask yourself, what proof do I have of these concerns? And oftentimes clients come to me and say, well, my child told me this, but the child's not going to be testifying in court. Very rarely is a judge going to allow a child to testify against a parent. So you have to think about what kind of proof do I have outside of what my children are telling me. If you believe there's an immediate threat to your child, the first step is always to contact the police or DHS and get them involved. But if it is not to that level where you need the immediate, right this second intervention, you can then contact an attorney and look at the possibility of filing an emergency motion to restrict that person's parenting time. Certainly, concerns about living conditions are something that need to be addressed. The question is it going to be an emergency situation where you could deny parenting time over that issue? And really, it has to hit that threshold where the child is in some kind of harm due to those living conditions. So not just it's messy, not just they're not getting a good enough diet, it has to be something that is an imminent threat to their safety. So if they're living in a situation where maybe they have roommates that are a danger to the children, or if they have a living situation where DHS would need to get involved because of how bad it is, that's a situation where you could justify maybe denying parenting rights or parenting time. Unfortunately, there are several situations where we've dealt with where one parent is concerned because the child does not want to go visit the other parent. And the younger that child is, the more difficult the situation becomes. Ultimately, again, the court is going to require proof for any kind of restriction that you're going to be requesting. Sometimes, if all you have is a child's word, you need to start out with finding out what it is they're concerned about, what it is they have issues with, and that may be a way of delving into getting more specific, concrete evidence of what is going on there that causes this reluctance by the child to do it. But if all else fails, it doesn't hurt to just reach out to the other parent and express these reservations and get some kind of text message or email message record of, hey, I'm expressing these concerns, how are you going to respond to that as the other parent? So it's very risky to deny another parent parenting time when you don't have a court order that allows you to do that. The court does have a process, an emergency motion to restrict parenting time if you have concerns. And if you choose to not go through that process, you're opening yourself up to all kinds of possible reductions of your parenting time, maybe being subject to legal penalties such as fines or even having to pay the other side's attorney's fees. So it's very important that you follow the proper process if you have concerns about the well-being of your children. That's why it's important to reach out to an attorney and talk about what your legal options are. If you're unsure about visitation rights or the safety of your child, don't try to handle this alone. Reach out to our team to get guidance on your situation and how you can protect your child's well-being.